3.5.1.2 publicly declares his or her intention to resign and /or publicly declares his or her resignation from the party. This is the clause that was applied to Mr. Lille, and the case concerns the meaning and the application of that clause and whether it's constitutional. One of the points made by the party is that it's a very simple determination. All the matters in 3.5.1 are really matters which are simple, easily to establish factually. Now that is not the case. This clause, if you go through it, contains all sorts of ways in which...
Sorry, I need to stop you there. We're going to run into trouble if we start talking about constitutional. So you're going to have to distinguish between the DA's constitution and the national constitution. You say that this is in conflict with the Bill of Rights.
Yes. Section 19.3, Section 16. But, my Lord, for the moment, the point is that none of these clauses, or very few of them, are capable of easy determination as to whether conduct falls within those clauses. Because if you, for example, look at 3.5.1.9, after being warned to desist, publicly and unreasonably disparages the party or decisions taken by its structures. So there's a lot of these clauses. 3.5.1.10 is the implementation of the recall clause. 3.5.1.13 is if you support the motion of no confidence in your own mayor, then you automatically cease to be a member, and so on. So what we say, and what Mr. Lille says at page 279 of the replying papers, none of these clauses have ever been invoked against any member but a public representative that the DA wanted to get rid of.
Mr. Duval, 3513, the cessation clause, you call it.
3.5.1.3.
Yes, the cessation clause. At page 77.
Yes.
You've termed it the cessation clause as opposed to the recall clause.
3.5.1.2, my Lord, is the one applied to us.
Sorry. I've underrun the wrong one.
She says...
Just a moment, please. Has that been in the DA constitution for an appreciable period of time?
My Lord, at least these clauses have been there at least since the decision of the Supreme Court of Appeal, those two at least, that we attached to the replying affidavit. So that was in 2008 decision of the High Court decision. Number is 2008, because you'll see a reference to them there. They've grown, my Lord, because we know that 3.5.1.10 has been inserted now at this last Congress.
Do we know from the papers when the applicant joined the party?
Lord, I would have thought it's 2007. Yes.
So the clause,
you can take
the clause was there when she joined the party?
Sorry, my Lord?
That clause was in the Constitution when she joined the party?
I wouldn't know that, my Lord. I would have thought so. Sorry, my Lord. She joined in 2010, I'm told. My Lord, at page 279, as we say, these clauses, and we'll refer to other examples as well, where they're not invoked and when they're selectively employed to target dissidents in the party. Public representatives, particularly when that public representative holds a balance of power and can cross the floor to another party so the control is given away over a council. They're not used in another context. Our submissions about 3.5.1.2.
Mr. Duval, are you referring straight to that article that depicts, for example, the DA leader,
yes,
Mr. Maimane,
yes,
who said something similar to?
yes, quite
yes, okay.
Maybe we just summarize our submissions. Of course, these will develop in the part B. about 3.5.1.2. It is facially unconstitutional and inconsistent with Section 19.3, and particularly the right to be elected to office and to hold office. Because we say it's implicit in that right, the right to hold public office, that you cannot be removed from public office without some good reason. This clause, we submit, is too vague and capable of being abused, and accordingly it is inconsistent with Section 19.3. Because, let's take a few examples, if I may use just two.
I'd like to hear you sooner or later, and I don't know whether it's you or Mr. Mpofu who's going to deal with it, what the prima facie right is that you rely on at this stage for interim relief. I know that these are all issues that are going to be dealt with in 2 weeks' time, but I need to have focus on what the prima facie right is upon which you rely, because there's an attack in the heads of argument on behalf of the DA that your affidavit is light on the prima facie right. So I don't know whether you're dealing with it or whether Mr. Mpofu is dealing with it, but we would like to hear you on that sooner or later.
It's on the three headings, my lord. Our prima facie right is, of course, determined by how strong we will be in the review in 2 weeks' time. Our prima facie right to the interim relief depends on whether we identify reviewable irregularities in and whether we will succeed in 2 weeks' time. What are the prospects of us being successful 2 weeks from now? That is how the strength of our prima facie right must be determined. Now, firstly, what we've already done is we have attacked in our notice of motion this clause facially, because we say it's vague, it's overbroad, it's capable of being abused, and it's inconsistent with Section 19.3. What if someone says, I will resign from the DA when I reach 70 years old? What then? Must you now immediately lose your membership? What if someone says, I'll resign from the party unless diversity, I'll resign from the party unless women get equal treatment? What about those statements? Because the way the DA wants to interpret this is not that it causes harm, not that you say you are declaring in public the intention to resign in a manner that causes the party harm. And that's why I read to your lordships 3.5.1.9, because there at least it says unreasonably. They want to interpret it to mean anything, any public declaration.
I understand the argument, the colleague will speak for himself, I understand the argument that this is one of the legs of the attack which the full bench will hear.
Yes. What?
I'm trying to understand what the prima facie right is that you rely upon now
My Lord,
for interim relief. There may be a difference between the two.
My Lord, if the decision was bad, because the clause is bad and unconstitutional, then of course I've got a prima facie right to the relief. In every tender case, in every review, the question is always, will he be successful ultimately to have the tender award set aside? Will he be able to get the liquor license in the end? So the question is, will we be successful in the review in 2 weeks' time with our argument that this clause is unconstitutional?
Well, do you have to go as far as that? Is it not, is the test not a prima facie right that are open to some doubt?
Yes, fine.
Well, then you don't have to persuade me that the point is anything more than arguable.
Yes, arguable.
Surely.
So, my Lord, our other points in my Justice Abela has already raised it. How are these clauses applied? And that's why we attach those examples from page 286 and onwards. What does Mr. Maimani say on 15 July 2016? I will resign if the DA doesn't deliver. Now again, what will be argued is, in 2 weeks' time is, oh, but you've got to understand this statement, the context indicates that he's saying, I'll resign as leader. But when we made that same argument, that the context it clearly indicated that Mr. Lille meant I will resign as executive mayor and not as member, then said, oh no, you just look at the words. He says here, I will resign if the DA doesn't deliver. Kola Barna, 2 pages forward. If I need to be, I will resign. She says, if you need to be, I'll resign. It's a conditional intention to resign. Why not apply it to that situation? 1 page further, Ms. Mvenya is in fact, in 2016, according to this press article, resigned in fact. The shock resignation of DA's Eastern Cape Provincial Chairwoman, Beliswa Mvenya, sent the party into a tailspin. Now they're all running towards her, according to the article, and say, please withdraw your resignation. Maimane and Zilla was locked in a meeting in a bid to come up with strategies to convince Mvenya not to leave.
So your argument is to the extent that there's procedural fairness that applies to the termination of membership, there's been inconsistent application of that principle.
Yes, indeed.
And that you say might afford you a prima facie right on review as well.
And if your Lordship look at the clearest example is actually the SCA in that judgment of theirs dealing with Ms. Jones. Because your Lordships will see there, it is recorded at paragraph 2 at page 294 of the judgment that his post became vacant consequence to his resignation from the municipality and as a member of the DA. And as a member of the DA. This is what happened. But of course after that, and in this particular instance, in George, it would have affected the balance of power. And you'll see then, as you read forward, Mr. Long then came to him and persuaded him, after he gave the ANC a letter of resignation, which they sent on to the IEC. Then Mr. Long said, please withdraw your resignation. And ultimately, that was done. And the case was then about whether his position became vacant or not. So, my Lord, we can go on with example after example, but the problem is that if you interpret it in the strict manner that the DA has proposed, doesn't matter whether it's conditional, doesn't matter that there's no subject intent, doesn't matter that it's later withdrawn. If those are if that's the basis upon context doesn't matter. If all of that is the case, then we would submit that the clause is facially overbroad and unconstitutional. That's our first point. If I may then go on to the second aspect, which is the procedural fairness of it all. Your Lordship would see at page 78, paragraph 3.5.3, the process or processes to be followed in the case of cessation under this section will be determined by the rules of the Federal Legal Commission. Page 78, paragraph 3.5.3. So how this is to be implemented, how they deal with, for instance, the argument that Mr. Lille lost the membership because of the public declaration of intention to resign, is to be determined by rules of the FLC. Those are to be found at page 120 and onwards. And if I can take your Lordships there and briefly explain our procedural points then, or as Mr. Porfo has put them, the non-compliance issues. From page 121, these rules for cessation of membership are set out. Now, we've got arguments that we set out in our papers on each of these. Paragraph 2, 3, 4, 5, and I'll briefly list them. Paragraph 2 at page 121. What should happen is, as soon as the relevant federal executive receives prima facie evidence which indicates that the public representative's membership has ceased, this must then be referred to the chairperson of the FLC. It says federal executive refers it. But Mr. South, we know, in fact, took the decision. He claims he's done so under delegated power, and your Lordships will find the delegation at page 257. That delegation apparently was done in 2002 and reiterated in 2011. Our argument is a simple one. The FedEx is reconstituted every 3 years.
Altovaro's point on this. Is there an ultra vires challenge on this
Yes.
paragraph? That's all we need to know at this time.
Then, paragraph 5 over the page, 122. Paragraph 5 at page 122. Your Lordship would see how this works is that they present a letter of cessation describing the basis upon which it's alleged that one's membership ceased. And then you have 24 hours after having been served with such a letter to provide the chairperson of the FLC with clear and unequivocal written reasons why his or her membership did not cease. So there are two things. You've got 24 hours. You can't provide an explanation. You have to give clear and unequivocal reasons, written reasons why membership has not ceased. Not just cast a doubt. Clear and unequivocally, you must persuade them with those reasons. Now, the only question is whether this clause, which we attack, is consistent with the rules of natural justice. Because you will see from page 107, if I can take you there very briefly, page 107, it's stated that the parties' rules, or the FLC rules, is subject to the Constitution. Well, on page 107 it says at 10.5.1, the rules of procedure prescribed by the FLC must apply to all proceedings of a panel, provided that the rules of natural justice must at all times be adhered to. Now, if you just turn 2 pages back at 105, one sees there at 10.1.4, the FLC may determine rules of procedure, but they may not be in conflict with the Constitution. So our argument is a very simple one.
Just a moment. Which paragraph are you dealing with? You said from 10.5.1 you go back to where?
Yes, back to page 105, my Lord, at clause 10.1.4. The rules of procedure of the FLC may not be in conflict with the Constitution. The question
It was
is...
the DA Constitution.
Yeah,
This
that's the
Constitution.
DA. Yeah. Yeah. So in terms of the rules that the FLC made, not in the Constitution, you've got 24 hours to provide clear and unequivocal reasons. The Constitution, however, requires rules of natural justice to be adhered to at all times. Is that in accordance with rules of natural justice, 24 hours, and placing that burden, which is referred to by the panel themselves as a heavy burden, with further presumptions also in clause 3 about what shall constitute sufficient proof of such a public declaration? Is that in accordance with the rules of natural justice? It's not difficult to decide that, my Lord, because the issue has already been raised in the Matheson case that Your Lordship, we haven't handed up our bundles, but if I can refer you to one passage of this. If I can take Your Lordship to page 47 of that bundle. Is this? At page 47, my Lord, this is a judgment
Is
that
it
comprises
one of the
of two.
floor crossing matters?
No, my Lord, I think this is post-floor crossing. It concerns two matters, but you will see in at page 47, if you just go over the page. at page 48. There are two matters being heard together before Goliath J. The second matter is the relevant Julian Matation and ACDP. Now, can I take your lordships to page 61 of this, where it sets out the relevant ACDP provision. Page 61, paragraph 25. Clause 2.13 of the Disciplinary Code of Conduct of the ACDP makes provision for the temporary suspension of a member pending an outcome of an investigation and disciplinary hearing. Clause 2.16 states as follows. A member thus temporarily suspended will vacate his or her party offices immediately upon receipt of such notice and will comply with all requirements and conditions of such notice. And then the important one, failure to do so will lead to the member's immediate expulsion and dismissal. So what happens is they suspend you, they impose conditions of suspension. If you don't comply with them, automatic expulsion. And Goliath Jajan explains in paragraph 26 how it works. And I'm paused here for a moment because my learned friends in their heads say this case is not dealing with an automatic expulsion. This is why I pause a little bit longer on this. Paragraph 26. First respondent argues that acted within the parameters of its disciplinary code. The applicant was instructed to withdraw his request for a special council meeting and motion of no confidence by 5 o'clock on 12 October, which he failed to do. The applicant was then suspended on conditions that he should withdraw the request by 5 o'clock on 13 October, which he failed to do. Hence is it argued that in accordance with Rule 2.16, if the member violates his suspension conditions, he loses his membership of the ACDP automatically by operation of law and without any further decision. It's the same argument as the DA is making in this case. He was fully aware, as indicated in the letter of 11 October, that he would automatically lose his membership if he failed to comply with the suspension conditions. And it goes on. The ACDP therefore argues that on the applicant's own version, he automatically lost his membership at 5 o'clock on 13 October 2012. It's by operation of law, and there's no reviewable decision, all the arguments you'll see in their heads. Now, the question here is, was there procedural fairness? This is what Goliath J envisages, or has to deal with, because if you lordship go one page further, at page 62, paragraph 28, she says, and the last sentence, I am in agreement with the applicant that the period of 48 hours given to him to respond to all the issues raised in the suspension notice was unreasonable. Applicant was not given sufficient time to prepare and present his case to avoid possible expulsion. Over the page as well, at page 63, paragraph 30, the last sentence. Not only was the applicant given insufficient time, now we're talking about 48 hours, not 24, without any presumptions, without any burden. Not only was the applicant given insufficient time to deal with all the issues in the suspension letter, but also the manner in which he was expelled was unfair, unreasonable, and not consonant with the principles of natural justice. Why? Because it was too short. It must be borne in mind that the termination of his membership was a drastic measure which would effectively deprive him of his seat and his income as councillor. Now, we say that the present situation is on all fours. She interprets the rules of natural justice and finds that a period of 48 hours is too short, given that one would lose your position as councillor. So there's every possibility that in 2 weeks' time, clause 5, designed or adopted by the FLC, will be found to be invalid, because it is inconsistent with the rules of natural justice entrenched in the DA's own constitution. Paragraph 6.
Paragraph 6 where?
Paragraph 6 of page 122. I'm moving on to another point. Was the panel that considered Mr. Lille's, and I'll be a bit longer on this one also, because here, with great respect to my learned friends, I cannot see how in 2 weeks' time they will get around this point, because it is the third time that I'm arguing this point, so it was argued before the Moorman panel and before the Joubert panel as well. Paragraph 6, what does it say? The chairperson of the FLC must, as soon as possible after receipt of the written reasons, this is now of Mr. Lille, presented to a panel of the FLC. So it's presented to a panel, and our argument is that the panels have never been properly constituted due to the manner in which they were originally.
Sorry, do you accept that it was presented to
Yes.
a panel? In the present case, it was presented to a panel,
Yes.
but you take issue with the constitution of that panel.
None of the FLC panels were originally properly appointed. And our argument here, if I can take your Lordship to page 305, which was the provision of the DA's constitution which applied at the time when all these panels were appointed. Page 305, my Lord. But just pause for a moment. It is one of the reasons why we say those disciplinary hearings against Mr. Lille has stalled. Because when we raised this argument, it meant that those panels were all improperly appointed. Clause 11.1.1 says this: FedEx must, at its first ordinary meeting after each Federal Congress, elect the chair and the deputy chair of the FLC. We know who they are. It's Mr. Horn and Ms. Brayton. Those are two that they do. Thereafter, the FedEx shall appoint a panel of 10 additional people who are as objective as possible, preferably including one from each province. So FedEx then appoints another 10. Then these 12, who together with the chairperson of the FLC will make recommendations to the Federal Council for the appointment of the other panel members. So one gets the first 12, and they then make recommendations for the appointment of the other panel members, until you have up to 20 plus 10 alternates. What have they done? Your Lordships will find what they did at page 173 with the appointment of these panels. At page 173, paragraph 14.2. Your Lordships got that?
Yes.
They refer to clause 11.1.1. But then it's recorded as follows. Historically, this panel had consisted of the 9 provincial leaders and himself being the leader the chair of FedEx. You'll see from the top, chairperson said. Historically, it consisted of the 9 provincial leaders and the FedEx chair himself. The leader indicated that they wished to be part of the panel. FedEx agreed to this proposal. So in the end, they thought that the panel envisaged by 11.1.1 that must select the other panel members can consist of 9 provincial leaders, Mr. Self, Mr. Maimani, and this panel then went to go and appoint all of the panels. And you'll find that 2 pages on, at page 176. The panel had, by means of a telephone conference, and had considered all the nominations carefully, taking into account geographical spread, so on. Following panel members were recommended to the Federal Council. So instead of FedEx, page 176, my lord. Sorry, I'm going. So instead of FedEx appointing the first 12, It had just constituted these provincial leaders, Mr. Self and Mr. Maimani, and then went to go and appoint all 20, which is clearly inconsistent with this. Now, we know that the Constitution is subsequently being amended. The new Constitution has been amended, but the panel that considered my client's representations had to be constituted in terms of this old procedure. Now, your lordships may
When
find
did
this...
the procedure change? At the most recent National Congress?
Yes. Now, your lordships may find this argument technical, and it's for this reason that we refer to your lordship in our bundle, or we'd like to refer your lordship in our bundle to the Crocombe decision, because, and it's in our heads of argument as well, because that argument was, if I may just find the reference to it in our bundle, yeah, it starts at page 22 in our bundle. And the relevant passage being page 22.8 of A, capital A, 28, capital A. So it is a technical point for some, saying that the panel wasn't properly constituted. What does the SCA say about this kind of argument? Page 22, capital A. It's common cause that the civic as a political party, paragraph 16, is governed by its constitution, which represents the collective voice of its members. This constitution spells out clearly when and how members of the civics NEC will be appointed and removed from office. It follows, therefore, that the NEC is constrained to exercise only those powers entrusted to them by the constitution, and strictly in terms of the constitution. This is in line with the principle of legality. Any conduct that falls outside the purview of the Constitution is therefore ultra vires and invalid. And then they go on to say, I've already indicated that as to May 2012, Damons had not been elected onto the NEC as its member in terms of the Civics Constitution. He was only co-opted thereafter. So there was a similar point in that Mr. Damons was taking part in an NEC meeting some 26 days before he was co-opted onto that NEC. And the SCA says, well, he wasn't properly there on the 2nd of May. He was only co-opted 26 days later. And that's why it's ultimately found. He therefore had no right to participate in the NEC's meeting qua NEC member. He was essentially a so-called stranger. And all the actions later, all those meetings, everything that happened there is set aside. Now, it's similar. One can just take Mr. Maimani. He had no right to be part of the decision to appoint the panel. The whole manner in which the panel's 20 members and 10 alternates were selected was accordingly invalid. But this is one step in the middle of the FLC procedure, which then, one cock in the wheel, which then falls away. And the decision must fall. But there are others as well, and we've listed them, and I'll go back to our heads now just to remind your lordship where to find them. Paragraph 9. Ultimately then, after the FLC makes a recommendation, FedEx then has the power to confirm the determination of the cessation of membership of the affected member. And the question is, does it then exercise a discretion? Sorry, my lords, at page 122, paragraph 9. So the FLC panel, which was improperly constituted, makes a recommendation to the federal executive, who then may confirm that recommendation. This introduces, of course, a discretion, which triggers our boni vire point, But also, how should that discretion be exercised? And there's a provision of the DA's constitution that, I remind you that this rule cannot be inconsistent with, which requires that the member must be able to put up mitigating circumstances. And your lordships will find that rule 10.5.1 at page 107 again. She must be given an opportunity to submit evidence of mitigating factors. Now, that can only be done after a conviction of a kind, and FedEx should then have given her an opportunity. Paragraph 10.5.1.2 at page 107. Now, finally, at page 78, my leader just reminds me, the final point being at page 78, that the Constitution requires that the provincial authority refer the matter, page 78, paragraph 3.6.2. If the membership of a public representative is terminated in terms of section 10.12, or if a public representative ceases to be a member of the party by virtue of 3.5.1, the relevant provincial managing director must notify the relevant authorities of the vacancy. Now again, it's not complied with, common cause, because at 150, you'll see that Mr. Self took on the responsibility again.
What is the consequence of that?
The referral, the notification is invalid, my lord. No vacancy arises. You can say that the party's procedure up to that point was fine, but how does the decision get to the city, the relevant authority in this case? It has to be done by the provincial managing director, not Mr. Self. Again, you can say these points are technical, but if I can take you back to the heads of argument, just the final decision of the Constitutional Court in a case that Mr. Mapofu was involved, is the Ramakatse decision. Perhaps I can just read the passage to you from the heads of argument, because I am going to go to the heads of argument now, my lords. At page 12 of our heads, and I'll just go through the various basis upon which we find a prima facie right in the heads of argument. At page 12, what does Ramakatse, what's the Constitutional Court say there?
What paragraph in the judgment?
Sorry, it's paragraph... That leader will find it. But it's in one of the two majority judgments in the Ramakatse. And the court says, I do not think that the Constitution could have contemplated political parties could act unlawfully. On a broad purpose of construction, I would hold that the right to participate in the activities of a political party confers on every political party the duty to act lawfully and in accordance with its own constitution. Now the important part, this means that our Constitution gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership. So as Krookamp says, we're looking for strict compliance. Ramakatse say you've got the right to exact compliance. My lords, may I just then list our points. I won't make submissions on them now, because they summarize them here on the prima facie right from page 12. Paragraph 20.1. This is our authority point. Sorry, my lord?
Are these now in your heads?
Yes, my heads. But I've dealt with them, and I'll just list them and refer your lordship back to what I said. Paragraph 20.1. This is the point that we made that Mr. Self did the referral and not FedEx, and that his delegation was invalid. That's in paragraph 20.1. Paragraph 20.2 over the page 13, is a point that I didn't deal with, but Mr. Self, in fact, never referred the complaint from Mr. Kopane about 3.55.1. He asked for the FLC's advice. He didn't refer the matter. Your Lordship will see at page 126. He asked for the FLC's advice on the complaint and not refer it for determination. Paragraph 20.3 is the unlawful constitution of the panel. Paragraph 20.4 over the page is what I've just dealt with now, which is the fact that Mr. Self referred or communicated the outcome of the process to the city manager instead of the relevant provincial manager. Then the procedural fairness points at paragraph 21 and forwards. The first one being that to the extent that one can superimpose PAJA on this contractual relationship, much like your Lordship did in the Parkscape matter.
Is that still good law at the moment, Mr. De Waal?
Well, Lord, I don't know where that appeal is, but the argument is that it's never been...
Is the argument on behalf of the applicant that PAJA does apply?
Alongside the contract, yes. I know that there are decisions, but the decision of Acting Justice Mansing says that PAJA doesn't apply to this, but there are, as the SCA summarizes there, varying responses, and no final decision has ever been taken that PAJA cannot apply alongside the contractual relationship between member and party. Lords, I'm told that the Constitutional Court left it open in Ramakatse as to whether PAJA applies to this.
So this is one of the further points that you intend to advance by way
Yes.
of...
Paragraph 20 over the page 15, paragraph 21.2. That point I've already argued now. This is that clause, the FLC rules are inconsistent with the rules of natural justice which is entrenched. 21.3 I haven't really argued up till now, but it is the argument that the FLC rules is also contrary to public policy, as it allows determination of a public representative's position without due process being followed. And public policy in this context, if we can hand up the Bredenkamp decision of the SCA, and I'm not going to take your lordships there, but just refer you to Bredenkamp, at paragraph 43, where the court, the SCA finds that public policy, the question of whether a contract is contrary to public policy must be determined in light of the values of the Constitution. And we intend to argue that these FLC rules and clause 3.5.1.2 is inconsistent with public policy because it undermines section 19.3 of the Constitution. Paragraph 43 of Bredenkamp is authority that one looks at public policy and determines whether...
Through the prism of the Bill of Rights.
Yes.
It's the constitutional...
Sorry,
Barcase and Mrs. Lake.
Paragraph 43 of Bredenkamp interprets and captures what Barcase, according to His Lordship Mr. Justice Harms, means in effect. That it's not this unruly horse. Anybody can say this contract is unfair and therefore it's against public policy. You've got to identify a particular provision of the Constitution, the Bill of Rights, which you say informs public policy, which the contract is inconsistent with. At page 15, paragraph 22, we deal with the Matheson judgment that I've already done. And then our substantive unfairness points are listed at page 16. And I've dealt with the first one already, which is that the clause is inconsistent with section 19.3, as well, of course, as the right to reasonable administrative action if PAJA applies. And we also say that the discretion was not exercised boni vire, and the rest of these submissions will then be dealt with by Mr. Mpofu. Those would be the part that I would be dealing with.
Thank you, Mr.
Nothing else.
Mpofu?
As a court, please.
Wrapping up, as it were?
Hello?
Wrapping up, an hour into injury time.
Well, not quite.
Sorry.
What I just want to contextualize first, in 2 or 3 sentences, the reason why.
Just a moment, please. There's a technical problem.
Okay, yes.
Thank you.
As purposes. I just wanted to contextualize why the material that my learned friend Mr. Duval had to deal with, how it fits in with what I'm going to say. Effectively, what we're saying is give the historical account in order to explain, as I said earlier, why this unlawful conduct was resorted to by the DA. But more importantly, the issue about what one might call the jurisdictional facts or tactical non-compliance with its own constitution by the DA. As my learned friend said, might sound technical, but at this stage of the proceedings, this is what it does. It simply says to this court, prima facie, to be resolved in 2 weeks, it would seem that the so-called cessation clause was not correctly applied. In other words, if you jump all sorts of technicalities, what that really means is that Mr. Lille is, as we speak, still a member of the DA, or if you want to be technical, you can say will be proved in 2 weeks' time to have been a member at this point today, as we speak. Now, the importance of that is central to this interim application, because you're going to hear for a long time that, but she's not a member. And because she's not a member, remember that is just the fuss that is used, not really because they're worried about the membership list of the DA. It's got nothing to do with that. What they really want is to remove her as a mayor. So the so-called cessation of membership is just a stepping stone towards what they really want to achieve, which is to take her out as a councillor and as a mayor. So once the edifice of the first stepping stone is removed, then what are we doing here? So the importance of what my learned friend Mr. Duval is saying is that if it can be shown, let's take any example. If it can be shown, for example, that at a particular point where she was entitled to Audi, that Audi was not granted. If it will be shown that the so-called panel was not properly constituted. If it can be shown that James Self didn't have the power to refer the matter to the council. A very important one. Ironically, the one that looks even more technical is the most crucial. Because remember, the fuss is that there's a vacancy, there's an acting mayor and all that. But let's just, for a minute, my lords, assume that this court will find that the referral of the vacancy to the city council, because this is now where the interface between the party and the council is, was defective. Boom. Then it's all gone. Then what we have is just smokes and mirrors, but in actual fact, Ms. Lille is still a member of the DA, is still a councillor, and she's still the mayor. So that material is important for that reason. But it's important for a second reason, which is what Justice Gamble was asking about. How does that then link to the question of the prima facie right? And again, we don't have to debate now whether PAJA applies and so on. Let's assume PAJA doesn't apply. Let's assume that all we have is merely the contractual rights between the member and his party, where Rabakata makes it very clear in the Constitutional Court that the relationship between a party and its member is the same as the old Jockey Club cases that the court will be familiar about, wherein it is said that a breach of that constitution is the same as a breach of a contract. In other words, that relationship is contractual. So even if you left it at that level, forget about fancy arguments about PAJA, which will be dealt with in due course. Then even at that level, there would have been a prima facie expectation on her part, at the very least, of audi alteram partem, wherever it has been identified. For example, yes. So that's the connection between those submissions.
Do I understand you well, Mr. Mbogo, that what you're saying that the procedural unfairness of the applicant resulted in her having this prima facie right?
Absolutely.
But then it will be again argued at a greater level in Part B.
Yes.
But presently, on account of this procedural, this is resulting in having.
Absolutely. And as the court pleases, and my lord, this ties up with what Justice Gamble was saying. Remember, at this stage, all we have to do is to show that those rights, procedural rights, as your lordship correctly calls them, are prima facie existent. The fact that in 2 weeks' time, on closer scrutiny, you might find that, no, this comma should have been there and so on. That's irrelevant for the purposes of this court. All the court has to say is that there is a right open to some doubt, even. In my respectful submission, it's not these rights that have been elucidated, they are not open to any doubt, but put that aside. This court has to determine is that there are those rights, and therefore, that's what I'm saying, the crucial thing about it is that, and therefore, if those rights are found to exist in 2 weeks' time, it's not going to mean that Ms. De Lille is a member in 2 weeks' time. It will mean that she's a member now, as we speak, of the DA. That's what this kind of relief is meant to do. It is meant to assist those parties who cannot wait for 2 weeks or 2 months or 6 months in most cases for the determination of their rights, so that we arrest the situation as it is now and grant relief based on that.
What about prejudice? Would then the applicant be prejudiced if she is not reinstated within these 2 weeks?
Yes.
And perhaps balancing it with
That's correct. No, your lordship is quite correct. In fact, that question goes directly to the fourth requirement, which is the balance of convenience. And as we say in our heads, the balance of convenience is an easy test, but which is usually misapplied. It's all that the balance of convenience test says is we must look at 2 scenarios. If she is unsuccessful in 2 weeks' time, let's assume that court finds, no, she was never a DA member. Her membership expired on the 26th of April. What inconvenience would the DA have suffered in that period? And then you have to flip it on the other side and say, if she is successful in 2 weeks' time, and she has been removed for the 2 weeks, what inconvenience would she have suffered in that period? Which is the question I'm about to answer. Subject to this, unfortunately I don't have the authority here, but it's probably trite that in a case such as this one, where clearly the interests of the public are concerned, one doesn't look at the balance of convenience narrowly, as just these parties here. Remember, when we say the applicant, we're talking about Ms. Patricia de Lille, Councillor, Mayor of Cape Town. So the inconvenience, just picture this. Let's assume now there's a so-called acting mayor. And for a minute, let's say there was the MACO, we know that it's not there. And all sorts of things that we might not know about that then happen from the fact that she has been unlawfully removed. And the citizens of Cape Town are also left in this limbo, where actually there's no MACO in existence as I'm standing now, where it's not clear who's the mayor, who's going to be the mayor, and so on and so on. Where she is kicked out basically and left out to dry in the you were falsely dismissed or terminated from membership. That's what the court has to weigh. And the court surely in a case like this has to say, firstly, what possible inconvenience can the DA, not the city, not the people of Cape Town, the DA, the political party, what conceivable inconvenience can they suffer if she is there for the next 2 weeks? Zero. Versus the multitudinal inconvenience, prejudice, and all sorts of things that will befall her and the people of Cape Town if this situation is left to linger longer. So, and then of course, going back to what my learned friend was saying, the linkage between the practical issues and the Constitution. Remember, it's paragraph 16, by the way, my lord, in Ramakatsa. That's paragraph 16 of the Ramakatsa case on page 32 of the bundle. I'm sorry.
Sorry, you were at Ramakatsa,
Yes,
paragraph
yes.
16.
Yes, my lord. I was just saying that that's the passage that my learned friend referred to, and they couldn't find the passage. Because he's already read it, I'll just read the first sentence. It says, I do not think that the Constitution, meaning now the Constitution of the country, could have contemplated political parties could act unlawfully. Again, assume that all this will be developed in 2 weeks' time. But let's look at what Mr. Duval has said. If what Mr. Duval has said is true, then the party has acted unlawfully, even in the narrow sense of not complying with its own constitution. let alone the fact that in Ramakata, I think it's paragraph 74, the broader statement is made, which again will be developed in the next leg of this case, where Musaneka DCJ says, I'll just read the first sentence. It bears repeating, it's on page 38, I'm sorry, 38. It bears repeating that political parties may not adopt constitutions which are inconsistent with Section 19 of the Constitution of the country. So, remember that the attack on the Constitution of the DA, or on the relevant clause at least, 2.5.1.12, Amendment 2, is going to be premised on that basis. That our argument is going to be like this in 2 weeks' time. Any clause in the DA Constitution that seeks to undermine all our fundamental right as citizens to join a political party of our choice, in terms of Section 19(2)(b) of the Constitution of the Republic. And that may compromise our right to be elected into office and to hold such political office in terms of Section 19(3)(b) of the Constitution of the Republic. Any clause that may undermine those two fundamental rights in our Bill of Rights is inconsistent with it, or rather is unlawful. And I can make a passing reference to the UDM case, the secret ballot case. I'll find the passage, I'll refer to it in reply. But essentially, what is said in UDM is the whole thing called the constitutional democracy or democratic government of South Africa, which is guaranteed in Section 1 of the Constitution. By our choice, rightly or wrongly, as South Africans, we have decided that our political rights will be exercised through the medium of political parties. In other places, it might be that people vote as individuals and members of parliament are chosen in constituencies and what have you. But here, we've decided that the political party is the mechanism through which we enjoy our democracy. And therefore, the political rights that are protected by Section 19, Section 1 read with Section 19, are sacrosanct. And therefore you can't bypass, because really, if you remember what I said in my opening remarks, what is being done here is to bypass all the safeguards of the law that protect a person such as a mayor and a councillor. Let me make a wild example. If, I'm making this up, let's assume that in removing a mayor, the rules of the council say you must give that mayor 2 weeks notice, let's say for argument's sake. And then it says in removing a councillor, you must give that councillor another 2 weeks. But the DA Constitution says in removing a member, you must give them 2 minutes. So you can't then circumvent the clear requirements of the Constitution in terms of the government of everyone, not your own political party, or by then saying, oh, okay, I don't have 2 weeks to play with, I'm just going to use this one, this shortcut, because then that person must come to court and say, no. That clause, so-called clause that you are using to get rid of me is unconstitutional because it offends against my entrenched rights. So I'm just making that example to show the relationship between this membership thing and the Constitution. So that, but again, those will be developed in full in 2 weeks' time. So that's Justice, you've preempted me because I was going to say in any event the two key of the four requirements that I'm going to deal with to save time would be prima facie and balance of convenience, because the others are self-evidently there. The harm, I've already referred to it indirectly.
Would you say then that, if I understood well, that the manner in which this case was triggered by the first respondent, the swiftness of at such and such a time, she was given a letter and all that, and within no time, in 2 hours' time, she is officially ceased to be a member of the party concerned. And that in itself indicated then that she had no other option, because she could not get a counsel within that time to say, well, because that's an argument from the first respondent, to get someone to challenge, say, now it's no longer interim, because now this is a final.
Yeah.
But between that time, it's very possible to get someone to say, okay, fine, before you do the next step, and then the papers are already there by challenging. But it's done so fast. Would you say that it was meant to target the applicant conduct, so that at the end of the day, we are here today?
That's correct.
But the applicant, who's now doesn't have a membership according to first respondent.
That's correct, my lord. Firstly,
The whole procedure, that at the end of the day, it directs on this, you have said, because I think your junior also said, it seems as if it was targeted at a certain individual, which there are some evidence here.
yes. Yes, my lord. And it goes to, that's a very important issue, because it goes to what I said is the fundamental thesis of where our attack, which is that this whole thing really is just something meant to, as I said earlier, insult the intelligence, even the intelligence of this court. Because honestly, in order to contrive this argument about the horses have bolted, or what's the other metaphor? The turning back the clock. Yes. It was to contrive that argument, but in such a silly fashion, I can't find a better word. Because the mayor says in reply, for example, that she's been a mayor for 7 years. She says in that 7 years, she has never seen anything like this. This swift action. At 8 o'clock, you get a letter to her. At 9 o'clock, the municipal manager Mr. Self is sending a letter to the municipal manager. 9:30, the municipal manager is sending a letter to the IEC. I mean, really. And then by 12 o'clock, by the time we then serve the papers at 12 o'clock, no, the horses have bolted.
But then was it not? Was then the applicant would have said that she had warned them that if you do that,
absolutely,
then we'll take you straight to court.
Exactly. In fact,
so they did that, knowing exactly that.
That's why it's really the most offensive.
The byline of our city is "the city works for you."
Well, it looks like, especially when it's getting rid of you.
They promise us service delivery.
Well, it works for you when it's getting rid of you even faster. But yes, my lord, what really betrays that whole facade is the fact that these people have been told repeatedly in all the correspondence of the past week that if you take any steps to get rid of her, we're going to court. Not only that, they've actually been served, as I said, as a matter of courtesy, with papers So that you know it's not an idle threat that we are going to go to court. You actually have been given a set of papers. So clearly, this super efficiency is, in quotes, is really meant to circumvent, to say, please send this to the IEC, please, before the papers arrive. And then so that when the papers arrive by 12 o'clock, then we are told under oath by Mr. Self himself that the horses have bolted. So I mean, no court is going to be fooled by such.
I must ask you now that you're 1.5 hours into injury time,
yes,
to conclude. So
yes,
we can take a lunch and adjournment and then start.
Then
early with
I
Mr.
appreciate that a lot. Let me just do it like this, because I'll come back to some and wrap up some of these points, but I don't want to leave out a crucial section, which is this. Remember, the reason we're here is the Makaiser interview. So I need to deal with that very briefly. So how then is this stratagem implemented?
Well, as far as that interview is concerned, and we're still waiting for a transcript of the full interview.
Yes, I understand it is ready.
But we'll receive it during lunchtime. We don't need to look at it now. Isn't the point simply that whatever was said has to be seen in the context of the entire interview?
That's correct.
Context is all.
And absolutely. And many. In fact, the laughable thing is that the panel, such as it was constituted, pretended to be applying the Endumeni case. But that's the last thing they did. The last thing they did was to apply Endumeni. Endumeni case says, as your Lordship just
but I mean, Endumeni relates to contracts and statutory instruments and the like.
No, it would be applicable with respect, my Lord. It would be applicable in the sense that Endumeni, remember, says that if you're interpreting any instrument. So let's say, for argument's sake, I take your Lordship's point. Let's say we are interpreting this instrument, which is the transcript. But it says that context is king. Very clear. Context is everything, which is why Mr. Duval had to take us and give us the whole context. Where does this thing come from? The past motions of no confidence, and so on and so on. And then Endumeni also says that you need to look into the background. Background is key. And then Endumeni thirdly says that if there are two possible interpretations, or let's say more than one, there might be 3 or 4. If there's more than one possible interpretation, then one has to choose the one that is more consistent with the commercial or business reality, or in this case, you would say the practical reality. So they defy Endumeni everywhere. How do they do it? They say, this is what you said. Mr. Makaiser said this, and then you said this, cut. It's like the old style censorship style of the apartheid. So you just cut. The part that censorship, by definition, is more important by what is left out than what is left in.
So I don't know that it's helpful to apply something like Endumeni to the transcript of a radio talk show. But for the purposes of
assuming
understanding what these two parties were talking about, it doesn't help just to look at a short clip. One has to look at the entire context.
Absolutely.
And the run up to it, because this seems to, as I recall, to have come at the end of the chat show.
Of the interview, yes. But my Lord, even if you look at the part where we give the answers, she says, Makaiser, and at this point I must concede, and anyone who has ever done a radio interview will tell you, my Lord, that sometimes, not even in court, I'm sure, the question goes this way, the answer is about something else, and then you say, no, I'm asking about this, and so on. But here, what is clear is that Makaiser, and I have to concede, mentions the DA. But when she answers, it's patently clear to anybody, even a child would tell you that she is talking about her position as the mayor. Because she says, yes, I've been in that position due to the, because of the, I'm sorry, because, the word because is important because it links the answer. Because really, it's not about hanging on to. I'm serving there, that's at the mayor's office, at the behest of the DA. The DA has gone through a process and the electoral college, they have put me into that position. I'm not representing my jacket. I'm representing the DA. This is the person who's supposedly saying I'm not a member of the DA.
Yes, I don't think we need to debate it with you at this stage.
Because
There are passages earlier on in the transcript which are clearly against you. And I wouldn't want to prejudice in any way at all.
Absolutely.
Maybe argued later.
Yes.
So can we agree on the basis that
It's arguable.
There are different spins to be placed?
Yes, absolutely.
To use the political
Absolutely. At this stage of the case,
on
my
the
lord,
interview.
yes, at this stage of the case, all we have to, once again, all we have to convince your lordships now is that it is likely that a proper interpretation of this interview will show that there was no intention to resign. Because remember, if you look at clause 3.5.1.2, the key words which affect this case are those, intention to resign. Because it says if you make a public declaration which amounts to an intention to resign, then there's automatic cessation. So even assuming that the clause was constitutional, which it is not, if there's no intention to resign exhibited by those words, then that's the end of the whole edifice. And then my learned colleagues make a fundamental mistake about whether the test is objective or subjective. Again, that will be ventilated properly. What they do is they use, because Ndumeni says you must look at the objective factors and so on and so on. Then they say, well, the test is objective. But no, you can't have an objective test for intention. Dolus. What you are looking for is intention to resign. That's the conduct. So intention to resign means something happening in your head. Your own subjective intention. So how are they ever going to prove that she had a subjective intention?
Well, we may get into that interminable debate around dolus eventualis.
I hope we don't get there. Yeah. If we do, thankfully it won't be in front of you, but we won't. Your Lordship is quite right. There are many grey areas, but at least at this level, what is clear is that. So remember, and this is a crucial point, my lord, what Ms. De Lille is saying, she's not saying, I resigned, and then I'm retracting. That she does, as she calls it, for the sake of good office. But she's saying, I have never resigned. That's a very different thing. And what takes the cake is the fact that Mr. Self says just listen to this at page 214. Paragraph 100. So the DA's version, there's nothing that helps. Yes. May I continue, my lord?
Certainly. Paragraph
100.21, my lord. You'll see there that there's no better witness for Ms. De Lille than Mr. James Self himself. He says, it is quite obvious that the applicant is simply seeking to avoid the consequences of her action. Then listen to this. When she made her statement to Mr. McKaiser, she clearly did not realize that they would lead to her losing her membership of the DA? Well, all I can say is thank you very much. If she did, she may not have made it. Thanks again. So, the DA says, subjectively, in her mind, she did not realize that whatever she was saying would make her to lose her membership of the DA. It's the same as saying she was just sleepwalking and she uttered some words. But so on what basis, honestly, can this court say, in the light of what Mr. Self is saying, say that it will ever be shown that intentionally that there was the existence of the intention to resign? If we accept that the intention to resign is the trigger of the whole thing that has brought us here. So absent the intention to, the subjective intention to resign, the whole house of cards must fall. And will fall in 2 weeks' time. But let me not be ahead of myself. So all we're asking at this stage is, and I take your Lordship's point, there's no point now in scrutinizing up and down the McKaiser report. But all we're saying is that this McKaiser thing was just used opportunistically as a waste of time. The real situation really is that, and this will be confirmed in Part B, real situation is that A, that clause is unconstitutional anyway. B, let's assume that it's not unconstitutional, then it was misapplied in the sense that it was of the points that Mr. Deval has made. And C, that even under the common law if you look at it purely as a contract between the two parties, that contract, quote unquote, was not complied with. And D, it's inconceivable that it will ever be shown that she intended to resign, which is a key element of the crime, so to speak. So on that basis, and then of course, I don't want to repeat the issues about the balance of convenience. The question is very simple, it's a rhetorical question. This whole saga, we all know, the court can even take judicial notice, has been going on at least for the past 6 months, since about December. The sky has not fallen in that 6 months. All we have now is another 2 weeks where we at least some semblance of good governance will happen, and not a fuss where these ones will come in, the other one comes back, and the other one is returned. I mean, that's it's just ridiculous. It's just also, it might be a waste of money, because you might have to pay people to do things and then tell them not to step out, and then have to pay her and so on. Again, we'll deal with those in detail. But what is clear is that what possible harm or further harm at that could befall the DA, again, I must emphasize this, the DA, not the city of Cape Town, not the citizens of Cape Town. What possible harm could befall the DA if in the next 2 weeks the status quo is frozen? Bearing in mind that in our book, at least, the status quo is that she's a member of the DA, she's a councillor of the DA, and she's the mayor, executive mayor of the city, for all the various reasons that we've explained. On that basis, I'm very sorry. If this thing about the horses bolted is being persisted with, I will deal in more detail.
Yes, you can deal with it in reply, I think.
I'll deal with in reply, in respect, just so that, in fairness, I warn my learned friend. I'll deal with it also in the context of Section 172 of the Constitution. In other words, this being a constitutional matter, the court in any event is entitled to give appropriate relief. But as I say, I'll elaborate if it is still being pursued.
Yes, thank you.
Because to council, we would like.
Could I ask that it always helps us in deciding these matters to have a draft order. Could you ask Mr. Duval to prepare something or just give us a draft order specifying exactly what the relief is that you seek?
We will.
So that we can consider the argument in that context.
As a purpose.
Secondly, going to adjourn now for lunch.
I'm sorry, my lord. Can I just say something? Just apropos what your lordship has just said. Yes. What will do really the real relief will be a breakdown of prayer 2.1, because as we said, that's the trigger. All these other things about vacancies follow from that.
Yes, that's why we prefer it in a
so
draft which consolidates
I appreciate
the case as it is. Secondly, we would like to get clarity on what the status of the current MACO is, and if the matter moves forward, which MACO is going to be looking after the citizens of Cape Town for the next 2 weeks, 2 months, whatever.
Yeah. My lord, yes, there is. Unfortunately, I'm not in a position to disclose the discussions we've had.
Yeah,
but
all I'm asking is that you give us
we'll give you an agreed position on that,
final
yes.
Position.
That's correct, please.
And then finally, before we adjourn, and this will apply going forward, I'd like to refer the parties to clause 10.6 of their constitution, which is at page 107.
107, ma'am.
Yes.
Thank you.
This is essentially a contractual matter between parties, and their constitution, their contractual arrangement, makes provision for a mediation of disputes. Everybody was in such a hurry to get to court that no mediation has been attempted or even considered. And we would simply draw your attention to that clause and urge the parties to think about the larger picture, about where these disputes really fall to be resolved.
Yes, my lord, if I may, it's not a definitive answer, but something that our position would be, there would be no harm, even if there is the draft order is given, there would be no harm in the mediation actually continuing. Because otherwise, the whole thing, remember, we mustn't look at it narrowly just from this case. We all know that there are 4 or 5 other cases going on.
I'm simply drawing it to everybody's attention because in the haste to get to where we are, people might not have read that far into the Constitution and they might have skipped over that.
I appreciate that one. No, I appreciate that one. That's God, please.
Thank you. We will take the lunch adjournment now and we'll commence at 1:45.
Thank you, my lord.